When you receive divorce papers from your spouse requesting to dissolve your marriage, it can be an overwhelming and confusing time. Signing the divorce papers is a big step, so it's important to understand the legal implications and what exactly you are agreeing to by signing. The divorce papers, also called the summons and petition for dissolution of marriage, officially start the divorce process. These legal documents state your spouse's intent to end the marriage and propose how to divide assets and debts, arrange child custody and support if applicable, and settle other divorce matters. Signing the divorce papers means you received notice of the requested divorce and agree to the local court's jurisdiction. Once served the divorce papers, you have a limited time to file a response, usually 30 days. Your response addresses each numbered paragraph in the petition and states whether you agree or disagree. Failing to respond could result in the court granting everything your spouse requested, so it's important to meet the deadline even if you agree to the divorce. By signing the divorce papers, you are not necessarily agreeing to the proposed terms. For example, you could sign to acknowledge receipt but then file a response contesting child support amounts or property division. Contested divorces typically require mediation or hearings to resolve disagreements. If both spouses mutually agree on the petition's terms, the divorce is considered uncontested. For example, if you sign the voluntary appearance form and file a response agreeing to all terms, the judge can approve the settlement without hearings. If you and your partner have already agreed how to divide assets, arrange custody, and settle other divorce matters, you can together file a joint petition for dissolution of marriage. This mutual divorce filing outlines the details of your divorce agreement to be approved by the judge. By both signing divorce papers up front, you save time and expense of negotiating terms down the road. You cannot be forced to sign divorce papers against your will. However, refusing to sign will prolong the process and increase costs. Your spouse can request the court allow alternative service like publishing a notice in the newspaper. The court may grant the divorce even without your signature if you fail to respond. While you are not required to have an attorney, it's highly recommended to consult one before signing divorce papers to ensure your rights are protected. An attorney can review the divorce settlement and advise you on the best course of action. Don't sign away your rights without fully understanding the legal implications.